Do you remember what he? Welcome. My name is Owen Egan, and I'm the West Hartford probate judge. We're here on the second installment of a four-part series called Understanding Probate, or formerly known as Demystifying Probate and Estate Planning. We're waiting on one of our panelists to arrive. We expect him shortly, but we thought we would start, and we wanted to be on time. So welcome, everyone. You're here for a great program tonight. We have three great panelists who I'll introduce in a minute, and they're all dedicated, devoted attorneys. They're all recognized in their field. By my count, when I look at all of the attorneys that are participating or have participated in this series, they've contributed about $100,000 of their time. So that's a great thing that they've done for this town. So we're very happy with that. We're very pleased. So thanks to all of them. But I'd be remiss if I didn't say thank you to Leah Farrell, who has set up this program at the West Hartford Library. She does a great job. Thank you. Jen Evans and her crew, who is filming this at Channel 5. I want to thank Jen as well. Give her a round of applause, please. Thank you. And so if anybody misses this or wants to go back, you'll be able to watch this on Channel 5. And Jen, I know, is happy to give you the link. So that's wonderful. I'm going to introduce the panelists. The way I'm going to work tonight is I'm going to introduce the panelists now. I'm going to give you a little bit of the history of the probate court, and then I'm going to let each of the panelists speak about their particular topic. And each of them have an interesting topic or interesting topics to address, and it should be wonderful. After that, they'll each speak for about 15 minutes. After that, we'll open it up to questions, and we want to make sure we have enough time for questions, and I'll moderate. So that's the way it's going to work tonight. So I'll introduce Anya Goldsby Wells, who's here in the green dress. And Attorney Goldsby Wells is a resident of Simsbury. She has a general practice of law located in West Hartford. She's an experienced estate planning lawyer. Attorney Goldsby Wells has served as a conservator and assisted administrators and executors with estate settlement. She is also an experienced estate planner. She is a trial lawyer who has litigated matters in both probate court and in superior court. She also serves as a magistrate presiding over small claims hearings in the Superior Court. Anya is deeply involved in community activities, serving on various boards and commissions, including the Freedom of Information Commission, which we serve on together. So welcome, Anya, and thank you. Next is Attorney Charles J. Shimkus, Jr. Attorney Shimkus is a lifelong resident of West Hartford. He has been practicing law for over 38 years. He is the principal partner in the law firm of Shimkus, Murphy, and Rosenberger, P.C., a general law practice located in Hartford with a concentration in real estate and probate throughout the state of Connecticut. His practice in probate includes estate administration and probate litigation. Attorney Shimkus is a trusted and experienced trial lawyer, having tried many cases in the state probate courts, the Connecticut Superior Court, and in the Connecticut Federal District Court. He is also an experienced estate planning attorney and he's drafted many wills and probate documents for many of his clients, and he's also very trusted and respected. So a round of applause for Attorney Shimkus. I guess I'll introduce Attorney Kearns, and when he comes in, we can give him a round of applause. He did tell me, though, that one of his children is expecting a baby. So if that interfered, he said, I'm going to take care of that first. I'm not going to. So that may be the issue. Attorney Kearns has over 37 years of legal experience. He's a lifelong resident of West Hartford. Attorney Kearns currently serves with the law firm of Bassetta, Kearns & Associates, located in Wethersfield, Connecticut. His areas of emphasis include estate planning, Medicaid or Title 19, if anyone is familiar with that, asset protection, elder law, and estate settlement. Attorney Kearns has drafted many estate plans for his clients. Attorney Kearns has not only represented fiduciaries in the probate court, but he has also served as a trusted executor and conservator and trustee in various probate courts throughout Connecticut. So we can give him a round of applause, and then we'll applaud him when he comes. Thank you. We'll just embarrass him a little bit when he comes in. So my father said you always have to give him a little bit of history, and so I'm going to leave you with a little bit of history before I step down. The probate court has been in existence in the state of Connecticut for over 300 years. It's hard to imagine, 300 years. Back then, there were 4 probate courts, one in Fairfield, one in New London, one in New Haven, and one in Hartford. And back then, they handled 2 areas of law. They dealt with the disposition of assets at death, and they dealt with guardianships or the care of people who had mental issues, mental disabilities or issues. So it might be, or incompetent people, children, that needed care because their parents had passed away. Those are the only 2 areas that the probate court dealt with. The probate court deals with many more issues now. The probate court deals with guardianships of persons, conservatorships, trusts, decedents' estates, disposition of assets at death, termination of parental rights, adoptions, paternity matters, emancipation of minors, commitments of persons with psychiatric disabilities. We have a psychiatric hospital here in the town of West Hartford. It is within the building for the Hebrew Hospital, which is behind the Jewish Community Center. It is the it's the Hartford Behavioral Health Hospital, and they deal with people who have psychiatric disabilities. The court goes there to deal with commitment hearings for individuals who need to be committed or may not need to be committed. We have due process hearings there and determine whether they'll stay or whether they'll go. And they work very hard with the individuals who are patients there. Name changes, to name a few of the things that the probate court does today. Probate court in West Hartford was established in 1982 when we broke away from Hartford. John Berman established the court here. The legislature established it here, but John Berman was the first probate judge. Sid Elkin was the second probate judge. Attorney Shimkus has a connection with both of them. He was a dear friend of John Berman's, and I think Attorney Elkin works with you, and he's a dear friend of Attorney Shimkus's. And then I'm the third probate judge in West Hartford. Probate judges are elected. They're not appointed as other judges are. Like other judges, they serve the court, and they serve until age 70. The probate court obtains its jurisdiction from the legislature, and the legislature grants the authority, and I listed some of the authority that the probate court has. If the legislature doesn't give us that authority, we don't have the ability to rule on it. The Superior Court can rule on other areas, common law as well as statutory law. We're a creature of statute only. In summary, the probate court deals with death and its consequences. It deals with capacity, conservatorships and commitments, and so forth, and parenting. That would be the extent of our jurisdiction. So where are we located? We're located on the 3rd floor of the town hall. If you haven't been there, please visit the court. We have wonderful clerks. They are kind, compassionate, and above all, they're knowledgeable. We have 3 clerks with over 30 years of probate experience. I'll mention those 3 now. We have 8 total, but those 3 are Gloria Rico, who is our lead clerk, and she has over 35 years of experience. She is consulted by clerks and lawyers alike with questions. She's hit with questions all the time, and she's kind enough to stop and answer those questions and then also perform her functions for the court. And she's wonderful. And as I said, they're all very kind and compassionate, and they're all willing to help. Marlene Karp has over 30 years probate experience, and James Felice, also very kind and compassionate and helpful. We have wonderful clerks, and so I'm very, very happy. They make my job very easy. I'm very blessed. The court, our aim is to assist and help people through the probate process. It is a people's court. Oftentimes you'll hear probate judges referring to it as a people's court. You don't have to have a lawyer to go in there. Yes, it's helpful to have a lawyer, but you don't have to have a lawyer, and the court will help guide you. The court cannot represent you. It's always good to have an advocate, but you don't have to have an advocate. We're very kind to lay people, so I just want you to know that. And the court's job is to be fair. My goal is to be fair and impartial and treat everybody kindly. My job is to work efficiently and to dispose of matters, in other words, finish matters within 30 days if we have a motion or a hearing that's before us. And I have given you all handouts for the session this evening. I hope you've all found one on your seat. That may be referred to by the panelists tonight. It was referred to before by the last group. And with that, I'm going to turn this over to Attorney Shimkus. And Attorney Shimkus, would you like to begin? Thanks, Chuck.
Thank you, Judge. Well, I'm here tonight to talk to you about that fun and exciting topic called your last will and testament. All right. So, most people know what a will is, right? That's what happens when I die, and that's how my assets are distributed. But you have to be a little bit more careful. The will only governs your assets that are in your name only, and that don't have a joint owner, that don't have a TOD, transfer on death, POD, or has a disposition through a designated beneficiary. As an example, your life insurance. Well, I have a designated beneficiary. Well, that doesn't pass through your will. That passes directly from the life insurance company to whoever your beneficiary is. One thing we find a lot is people set up a bank account. They may set it up with their daughter, their son. Well, I did that because, it was convenient this way. My daughter, my son could go down to the bank and make my deposit. Well, what they didn't realize is they set up a joint account whereby that asset that's in that account doesn't pass per the terms of the will. That asset passes directly to the daughter and is circumvented the will. So it's very important to remember that when you do set up an account and you have a named beneficiary or a joint owner, that asset, even though you may have a will, is not going to pass per the terms of the will. The other question we get a lot is, well, do I really need a will? My estate's not that large, and quite frankly, it's just going to go to whoever it goes to. Well, I think you do need a will, because if you don't have a will, then your estate is going to pass by intestate succession. Intestate succession means that the statutes of the state of Connecticut are going to dictate who receives the particular asset. And I did bring it with me tonight, just a little cheat sheet on how your assets would pass. And we're talking about your assets in your name only if you don't have a will. If you have a spouse and no children or a parent, the entire estate goes to your spouse. Well, that's okay. That seems like not a bad result, right? Then you have a situation where you have a spouse, a parent, but no children. Now it's going to get a little bit more difficult. The first 100,000 of your assets are going to go and 3/4 to your spouse, and the remainder is divided amongst your parents. Well, you think about kind of how odd or uncomfortable that could be. Your spouse gets the first 100,000 and 3/4 of the rest, and then your parents are divided equally for that last 1/4. So again, if you have a will, your will's going to dictate how those assets pass, not this particular statute. One other one that I'll show you is a spouse and children. If you have a spouse and children, the spouse takes the first $100,000 and half of the remaining portion of the estate. Who gets the other half? Well, the children get the other half of the estate. If you have 2 children, they each get a quarter. And so you have a situation where you can end up with an estate that's divided between a spouse and the spouse's children. And the decedent's children can be awkward, can be cumbersome, and probably not the way the decedent wanted the estate to pass. So the answer to the question, do you need a will? Yeah, you should have a will. So I wanted to talk now about the anatomy of a will. And a will is a document signed with the presence of 2 witnesses, and basically it has the following elements. The first part of the will describe that this is your last will and testament, and you're from this particular jurisdiction. That's called the extordium clause. It's the first paragraph in the will. Typically, the second paragraph could identify who your beneficiaries are, your children, your spouse, aunts, uncles, brothers, sisters. Or it could go right into what my wills do, which is to go ahead and say, whatever debts I had at the time of my death, please pay them first. If there's probate court fees, if there's estate taxes that are due, if there's last sickness debts, if there's any debts I had when I passed, pay those first. Thereafter, you'll go ahead and have potentially a provision that's a bequest. A bequest, maybe I want my watch to go to my oldest son, or I want my coin collection to go to my daughter, or my stamp collection. Not all wills have that, but some people have particular items that they want to have go to a particular person. Those are bequests. You then also can have a residuary clause that basically says, whatever else is left over, after I've made my bequest and after I've paid my bills, I want to go to this particular person or persons. That's the residuary clause. And what's nice about a residuary clause is people say, well, gee, my assets change all the time. Sometimes I have a bank account, but then I might liquidate that and take that account and bring it over to a brokerage house. I may have a piece of real estate. I sold the real estate. I bought something else. The residuary clause is just that. Whatever the residue is of your estate will pass to whoever you delineate as part of the residuary clause. So you don't have to keep going back and changing your will every time you change your asset. The other thing a will does is it names an executor, someone that's going to probate your estate. Now, an executor is what you have when you have a will. If you don't have a will, the court is going to appoint someone as the administrator, or administratrix in the female. And basically, that's the probate court deciding that this particular person is going to be the person who probates your estate. Well, the will allows you to make that decision. That paragraph that names the executor also will typically excuse the executor from posting a bond. If you don't have an excuse language within the body of your will, the court may, and probably should, go ahead and have a bond put in place for whoever is your administrator of your estate. A bond can be expensive, and frankly, sometimes a bond can be difficult to obtain, especially if there's any credit issues with the particular person. So again, a will allows you to decide who's going to be the person that probates your estate. The will also can name someone if that particular person can't act for whatever reason, that successor would step into the shoes of the executor. The will also can go ahead and name guardians for your children. If you have children that are under the age of 18 years old, you may want to pick certain people in your family or your friends that are going to go ahead and take care of your children. Not manage their assets necessarily, they could, but go ahead and take care of the day-to-day needs of your child. Your will can do that. Your will can also name a successor if that particular party can't act as a guardian. The will also can have within the body of the will testamentary language that indicates who will handle the money for the children till they reach a certain age. And I guess I see that Drew Kearns has just come in. No baby?
Not yet.
Not yet. All right, well, if you run out of here, we'll know you got a...
She's in labor, yeah.
Oh, gee.
I had to go get the 2-year-old down in Yale, New Haven. I thought he'd be back, but...
Well, I'm going to talk fast then. All right. So, the will allows you to make these types of value judgments, these types of decisions on the disposition of your assets, as well as who's going to handle your estate. Also, as I said, can go ahead and you can make decisions on who will care for your children if they're under the age of 18, and can have testamentary trust language within the body of the will that indicates that, well, if there's a particular child that is going to be the beneficiary of an asset and they're under a certain age and you don't want them to receive that asset just then, it can be put into a trust with a trustee administering for the necessary care, support, and maintenance of that child. And then at a certain age, typically, then the corpus, whatever left over in that trust, would be distributed to the child. So as you can see, the will can do a lot of different things. It also makes it a lot easier to probate the estate just in general. If you don't have a will, and you're the administrator of an estate, and you want to go ahead and do any type of transaction that is a significant transaction during the administration of the estate, you need to go back to the court and get permission. A will allow you to give that power within the body of the will. The executor will be given a long laundry list of powers, including sometimes incorporating the Connecticut Fiduciary Powers Act, that gives wide latitude to the executor. And that's important because you don't want to have to incur the time and the expense of constantly running back to the court during the administration of the estate to get permission to handle a transaction. So again, another reason why you want to have a will. Now, who can execute a will? Well, a will can be executed by anyone that's 18 years or older and has testamentary capacity. Now, testamentary capacity is not exactly formulaic. Obviously, it's a judgment on whoever is going to witness the will as well as take the oath of the witnesses to make sure that the person who's executing the will not only is of age, but has the capacity to understand that they're signing a will and the object of their beneficiaries. So that's a judgment typically made by the attorney who is handling the execution of the will, and it's not an easy decision sometimes because there are people that may be a little bit on the cusp, and you also have to guard against any potential undue influence from any other family members or friends when you meet with the client. So when we take a look at a will, we say, okay, I'm going to do my will, I'm going to execute my will. What happens if things change in my life? Well, you can change your will or you can revoke your will at any time. Number one, you can certainly execute a new will and tear up the old will. You can tear up your will and not have a will and go back to intestate succession. So the fact that your life may have changing circumstances doesn't make it so that, well, I'm stuck with this will, I have to live with this will of what I've made those decisions. You can change the terms and conditions of your will. I can tell you I've had people in my office change their will 5, 6 times, during the course of their life. I mean, I've even had a client that after Christmas, she changed her will every year. And you can well imagine, I got a Christmas card, I got it from Becky, but I didn't get it from Ruth. Guess what? Ruth's out, okay? And then I've also had other clients that have items of sentimentality that they want to pass through their will. Now, one of the things that we see a lot when people come to us is they say, well, gee, I'd also like my will to say I want to be cremated, I want to have the service at First Church of Christ, I want to have this reading done, I want this song sung at my funeral. The will doesn't cover that. Because quite frankly, sometimes the will isn't even reviewed till maybe a week or two after you've passed away. So the will doesn't deal with those type of issues. So what we tell people is, go ahead and make those arrangements with a funeral director, with a family member you can give that information to. And so don't count on the will to have that information in it. A will also doesn't cover a DNR, do not resuscitate. That's something you want to do with your doctor. And people in this room are too young for that anyway, but the bottom line is there may become a point in your life where you may want to have a DNR. That's not done through your will. So those are the elements in the anatomy of a will, the reasons you have a will. And as you can see, although it may be somewhat expensive to people to do a will, it really has a significant cost savings when you ultimately go ahead and have your estate probated. So in many respects, it's a benefit to your family, and especially a benefit during a time when family's going through the grieving process as it is. It's much better for them to have a roadmap as to how you wanted the disposition of your assets rather than having the Connecticut state statutes make those decisions. So that's what I have about the wills, and I'm sure there'll be some questions later.
So Chuck talked to us about one of the primary building blocks of an estate plan. We have others who are going to talk to us about the other building blocks. Building blocks of an estate plan consist of a will, an appointment of a conservator, a power of attorney, a living will, and a healthcare agent, appointing a healthcare agent. And all of those things will be discussed tonight. But thank you, Chuck. That was excellent. A couple of things that Chuck emphasized is that there's a difference between basically assets that are probatable and non-probatable. The assets that are probatable, in other words, they go by the will, according to the will, are those assets that you own solely. Chuck talked about other assets that you don't own solely, might be, or that are directed by directions such as a transfer on death clause or a joint account that you own with someone else. The survivor becomes the owner of that account when you die. Those don't go through probate. You don't own those solely. An IRA where you've designated a beneficiary, a loved one as a beneficiary, that will pass outside of the estate, the probate process. Chuck talked about intestate versus testate. And I just wanted to tell you, intestate means you die without a will. Testate is when you die with a will. Testate comes from testator. The person who is making the will is called the testator. Intestate means I don't have a will. If you don't have a will, the state of Connecticut, as Chuck said, will tell you where your assets are going to go. And you don't want that. Everybody should have a will. You should tell the world, this is where I want my assets to go, whether it's to the American Cancer Society or my 3 children or to some other loved one. Wherever you want it to go, that's where it should go, and you should dictate that. Chuck talked about a bond. A bond is an insurance contract, and it basically is required in an intestate process because you haven't appointed an executor. And if you didn't say, we waive the bond in your will, then your estate might be forced to purchase a bond. The insurance contract prevents against the executor or the person in charge of the estate from basically stealing or defalcating the funds. If they've taken the funds, then the estate could replace, the probate court could replace the executor or the person in charge of the estate, the administrator, and then they could go after the bonding company. The bonding company would pay whatever was taken by the executor who was not trustworthy, and then the bonding company would chase after that executor who took those funds. And one last thing I just wanted to tell you, there is no reading of the will. There is no reading of the will. I know you see that on TV, but we don't do that. We appoint executors based on the will that's there. We do look at the will and we make sure that it's abided by, but the will is introduced, and if no one objects, the executor is appointed, and it sets forth the roadmap on how the assets will be distributed. So that was excellent, Chuck. Thank you. So next we will hear from Anya Goldsby-Wells, and Anya will be talking about incapacity planning, the use of a trust, the use of a power of attorney, and perhaps a little bit about life insurance and assets that are transferred on death. Thank you, Anya.
All right, thank you so much. So most of what I'm going to talk about today is incapacity planning. So is anybody familiar with that term, incapacity? You probably hear it. I'm seeing some people shaking your head. So the idea of someone being incapacitated. Oh, sure. Let me make this a little closer. How's that, better? Oh, wonderful. Okay, normally I'm yelling, so I didn't want to be too loud. So the idea of the word incapacitation, or to be incapacitated, essentially means you lack the cognitive abilities to make decisions for yourself. So when we're talking about incapacity planning, that's what we're thinking about. when you get to a point where maybe your mind isn't where it used to be, a lot of people may start to develop symptoms of dementia. There's other things that can acquire in older age. You want to plan for that ahead of time, because the last thing you want is when you're in a position where you can't make decisions for yourself, other people are making decisions for you, but they're not the person that you want or the person that you trust, or they're making decisions that are not within your wishes. And so that's what I mean when I'm talking about incapacity planning. I'm also going to talk about conservatorships. Some people call it conservatorships. I say conservatorships, tomato, tomato, same thing. But I'm going to start with conservatorships first. And so when we're talking about conservatorships, we first need to figure out essentially what is it and when and why it's going to be needed. I'm also going to talk about the actual conservatorship process, how you can appoint a conservator, how the conservatorship usually works in court, and then I'm going to talk about some of the incapacity planning, because that can also be utilized to maybe prevent a situation of a conservator being appointed. So what I want to do is go off of a real world example. And so I'm going to use Sarah. So Sarah is my example today. Anyone named Sarah in the room today? I figured I'd pick a popular name. So Sarah is 78, and she is diagnosed with early stage dementia. She lives alone in her home. She has substantial assets, but she has no planning documents. So she doesn't have a will set up. She doesn't have a power of attorney, any of those other things set up. No healthcare proxy. And she has adult children that are very concerned about her safety. And sadly, Sarah recently fell victim to a financial scam. And so Sarah's phone rang about 1 month earlier, and someone on the other end asked Sarah for her bank account information, and she thought that this was somebody that she trusted. It sounded like a voice that she knew. It sounded like it was her son Jim on the other line, but sadly, somebody used AI and cloned Jim's voice and said that he needed some money and needed to get access to her bank account. And so I know that this is scary, but in the stage of where we are with technology, these things are happening every day. And so sadly, her bank account was compromised and she lost a lot of finances because of the situation. So we will have to ask ourselves, what are options that Sarah has? What can her family do to help her? And so we're going to answer that question, but I want you all to think about that scenario as we sit here. So let's start with what is a conservatorship. So essentially, a conservatorship is a court-supervised arrangement. And so I want to emphasize that. It's court-supervised. So this is where someone is appointed to help you as an adult who cannot manage their own affairs. That's what a conservator is about. And there are two different types of conservatorships. One is the conservator of the person, and the other one is the conservator of the estate. And so I'm going to break down what the differences is between the two of them. Essentially, the conservator of a person focuses on their health care decisions, things that deal with their personal care. So where the person lives, what type of medical treatment they receive. Those are the things that the conservator of a person makes decisions for. The conservator of the estate deals more with the financial aspects. They might have to pay their bills. They may need to submit a Medicare or Medicaid application. They need to protect their assets, paying the bills. That's the conservator of the estate. And so sometimes when people are appointed as conservators, they are appointed only as conservator of the person and conservator of the estate. Sometimes you'll have one person that does both. Sometimes you'll have two different people. So these are things you want to think about and consider as we move on to talk about the incapacity planning of who you want that person to be. I counsel a lot of clients that believe that only a certain type of person can manage their finances, and they would rather a different person to help them with their other aspects because it's a bit more intimate. So these are things you want to start thinking about. So with the conservatorship, there's also two different ways that a conservatorship can be filed. So one is an involuntary conservatorship, and another one is a voluntary conservatorship. So I'm going to start with the voluntary first. So the voluntary conservatorship is just as it sounds. It's you voluntarily agreeing for someone to represent you on that behalf, whether it's the conservator of the estate or conservator of the person. And so you're requesting them to assist you. You also don't have to essentially have a finding of incapacity. Most of the scenarios that I see with conservatorships deal with someone, as in Sarah's case, that has some kind of deficit. So if she is developing stages of dementia, that means she is not in a position to make informed decisions about her medical care or about her finances. And so having someone appointed as her conservator makes sense. But depending on what stage she's in and where she is, she may be in agreement to say, you know, I'm forgetting a lot of things lately. It might be a good idea to have my daughter be my conservator. So that would be a situation where it would be voluntary. When we have involuntary conservatorship, that's where we have to have a hearing, and it requires a standard, which is clear and convincing evidence. So you don't have to necessarily know all of the legal jargon, but essentially it has to be substantial enough. So if a judge is seeing the circumstances of this case, they need to have something to show that this person actually needs a conservator. And so one of the things that helps with the involuntary conservatorship is that an attorney is appointed to represent that person. And so let's say I'm Sarah's daughter, Melanie, and Melanie is seeing that there are issues going on with her mother, Sarah. She may be what's called the petitioner in this particular case. So that means she is the one that has filed the petition in probate court, but the purpose of the petition is to appoint a conservator for her mother. And so maybe she wants to volunteer herself. She says, hey, I've worked in the financial industry. I have the ability to help my mother, and I want to be that person. But maybe Sarah says, I don't really like Melanie. She hasn't talked to me in 5 years, and I don't really like her husband, and you know what? We're just not really in a good place. I don't want to do it. She may realize that this is something she needs, but maybe she's stubborn. Maybe she just doesn't really want to do it. There's all sorts of reasons why people may not want to agree to a conservatorship, and that's when we have the involuntary petition. The other thing that's important with the involuntary is that we require medical evidence. So that idea of incapacity is required. So there is something called a physician evaluation that has to be submitted with the petition. So you need a doctor that can evaluate Sarah to say she has dementia. The experiences and the things that she has going on right now, I think, put her in a position where she is incapacitated. She can't make decisions for herself. She's not able to manage her own money, and she can't manage her own medical care. So a doctor has to say that. So when you file the petition in court, your documents are going to include the physician evaluation, which has to be done within 45 days of the petition, and then a hearing is going to be held within 30 days of the petition. And then at that point, it's going to be up to the judge to decide whether or not you prove the case by clear and convincing evidence. So that's the two different types of conservatorships. With the involuntary process, I don't know if I mentioned, but it is important to note also that there will be an attorney appointed for the person in the involuntary process, because they want to make sure that their interests are being met. So if Sarah, in this particular example, does not want her daughter Melanie, she has an attorney that can advocate for her. So if she is in a position where maybe she can't make certain decisions on her behalf, she still has someone there that can advocate for what it is that she wants. Another thing with conservatorships I want to talk about is also what a conservator actually does and how to communicate what the person wants. So if you are a conservator, your role is not to just do whatever you want. You are acting on behalf of the other person. And so I think where sometimes the line can get tricky is that if you're dealing with someone that may have dementia, that may have certain wishes, and then sometimes maybe says different things. They may change their mind. They may speak in circles. I recall a client recently that would call me constantly to ask for me to do one thing, and then I'm trying to explain a concept to them, and they would completely forget what we talked about in the last conversation. And so it's very difficult to represent someone or to advocate for their wishes when you're not clear what those wishes are. But your role as the conservator and my role as the attorney at times is to really try to figure out what is it that this person wants. And sometimes it's not always going to be difficult, but you do have to consider their position when you are doing things on their behalf. And so with conservatorships, there's a specific standard that it's called the least restrictive means. And essentially what that says is you need to maximize their independence and self-determination, providing opportunities for them to be independent, to say how they want their money to be used. So if someone says, I want to go to McDonald's for lunch every day, and you know that their doctor is telling them, well, it's probably not a good idea to eat McDonald's because you have high blood pressure, how do you balance that? You have to follow what it is that they're telling you and manage their assets accordingly. But at the same time, there's going to be a balance that you have to consider in those situations. The other thing that I wanted to talk about is the oversight of the court when it comes to conservatorships. So as I mentioned before, a conservatorship isn't a situation where that person can do whatever they want whenever they want to. It's an oversight process. So the court requires them to file reports. If they're a conservator of the estate, they have to file reports to show that they're actually utilizing the funds properly, how much is in their actual estate. All those sort of things are required by the court so that they can monitor it, because there are certain things that they can't do without court permission. So there are certain instances where you would have to come back to court, even if you've already been appointed as the conservator, or if someone has been appointed as your conservator. If you wanted to move out of the state, for example, or move out of the country. I had a case a few months ago where someone wanted to literally move to another continent, and they had just gotten appointed a conservator. There are things that need to be considered. Are there doctors in the place where they want to move to? How are we going to manage their assets and finances in a different country? Who's going to take care of them? These are things that matter. If you want to change, let's say sell certain assets in terms of real property, if they're residing in one residence and now they want to sell it, those are things that you have to get permission for the court in order to do that. There's certain other things as well, so I won't go over all of them for the sake of time, but it is important to note that the conservatorships only have a limited ability to do certain things. So they don't have unfettered ability to do any and everything that they want, and they're really supposed to consider the conserved person in the decisions that they make on their behalf. That's really important to consider. One thing that I will say is that when I talk to people, and I know the other attorney is going to talk more about some of the other incapacity planning, but I do often get questions of, well, when is there a need for a conservatorship if I already have a power of attorney in place, for example? So I'm seeing some nods. So that's going to be a case-by-case basis. Typically, what I would say in those circumstances where you already have a power of attorney in place and someone is able to manage your finances, they have access to your bank account, I think it really comes down to what sort of things do you want to give this person access to do? Do you want someone to make those decisions for you? Do you want someone to guide you throughout the process? So you have to sort of think about who the person is that you're appointing and what your circumstance is. I'm not going to get into the other guy's presentation, but there are ways that you can plan for not having to go to a conservatorship if you do things ahead of time. So one of the things, if you plan ahead, you can choose essentially who the person is. So there's a document called the living will that allows allows you to designate certain things, and one thing you can list is a conservator in the future. So right now, you may be in a place where you're not incapacitated. You can make decisions on your own just fine, but you want to plan for the future. Just in case you get to that stage, you can list who you want that person to be ahead of time, and the court will consider that if and when that time does come. Another thing to think about in terms of incapacity planning as well, I know Judge Egan mentioned life insurance. There are a lot of things that you want to consider when you're in a stage of life and you're planning for that inevitable future. I know no one wants to talk about dying, I know, but we know that that time comes for all of us at some point. So the more we plan ahead of time, the better it's going to be, not only for us, but for your loved ones, those that are going to be there when you are no longer going to be there. And so it's important to try to put your wishes out there on paper. So there are a lot of different ways to do that, to think ahead. Having life insurance is something that's important to think about in terms of assets when you do pass away. There are a lot of ways to manage things while you are still alive. I know there's another presentation that we will be doing, I think next month, that talks about trust, but that's also another mechanism of which you can reserve assets that you want that don't necessarily have to go through the same probate court process, but those are assets that can be used for a specific purpose. So Attorney Shimkus talked about the will. The will specifically only goes into effect when you pass away, but a trust can be used while you're alive. So there's a lot of different ways to use a trust, and you can actually put specific limitations on what those assets in the trust can be used for. Okay, so there are a lot of things that I could say about that, but I think for the sake of time, I will stop there, and I'm looking forward to answering any of your questions later, so thank you.
Thank you, Anya. That was great. Couple of things I just wanted to highlight that Anya just emphasized. She talked about two different types of conservator of the person, conservator of the estate. The estate is the money, and the conservator of the person deals with the personal matters, including medical matters for the person. She talked about voluntary conservatorships and involuntary conservatorships. Voluntary conservatorships are really when someone says, I need help, and they're competent. In fact, the court has to make sure that they're competent and they know what they're doing. And they're saying, I just can't manage my bookkeeping. I can't manage my checkbook. I need it, Attorney Shimkus, or I need a loved one to manage my affairs. It could be anyone here, or it could be someone in your family. And the court makes sure that the person understands that that voluntary conservatorship can be terminated at any time. So the person may have appointed any of the distinguished members of the bar that are here, or they may have appointed their loved one, and then they say later on, geez, you know, I really don't want that anymore. I'm capable of handling my affairs now. I'd like to do that on my own. And they could terminate that voluntary conservatorship because there's been no finding that they're incompetent. And that makes sense. And I have to make sure as a judge that they understand that before I appoint a voluntary conservator. Anya talked about making sure that you use a document that names that conservator in advance. You don't want the court, you don't want the government to tell you who is going to be your conservator. You want to dictate who that will be. That's your prerogative. So if something happens where you are incompetent, you want to be able to say, I want my spouse, I want my child, I want someone to be the conservator. I don't want some stranger that's appointed by the court. Court will generally appoint someone who's close to you, but you really want that power, and you want to maintain that yourself, and that was one of the points that Anya was trying to make. You want to take control. And the hearing for the removal of someone's rights is a due process hearing. And the standard that Anya talked about was clear and convincing. It's a very high standard. We don't just take away someone's rights willy-nilly. They have to prove, the people who are petitioning have to prove with medical evidence and then other evidence that they testified to that their loved one needs a conservator. So, you know, you can file a petition for someone and say they need a conservator, and they might not be doing things the way you like them to do things. They might be giving all their money to their partner or their newfound love, and you're a child, and you think that's not right. I don't want that money to go there. Well, you know, they have a right to do what they want with their money, and they might not be doing things that they did before, but they might be competent. And so that decision has to be made after a due process hearing. You don't take away someone's rights. We wouldn't want anyone to take away our rights. I wouldn't want someone to take away my rights without a hearing with a high standard. But excellent job, Anya. You know, with that, we'll turn it over to Attorney Kearns. Attorney Kearns is going to talk about powers of attorney, the living will, advance directives, and the healthcare proxy. Is that correct, Attorney Kearns?
It is.
All right, come on up, please.
Thank you, Judge Egan. As Judge Egan said, my name is Drew Kearns. I've been an attorney practicing in West Hartford and surrounding areas for almost 40 years. I was born in West Hartford, continue to reside here. I love this town. And I want to thank Judge Egan for actually presenting and organizing this series, because there's a few sayings about knowledge. Knowledge is power, knowledge is strength, and it really, really is in the end. So the more you hear things and the more you may be exposed to what we have to talk about, I think you develop a better understanding about the things we're going to talk about. Now, Judge Egan might have alluded to what a harried afternoon I'm sure you're thinking I'm having, and it happened. I warned Judge about a week ago. I said, hey, it's my daughter's due date, and I'm the wheelman to go get my grandson, who's 2, if she goes into labor. So I keep on checking with her, and I'm okay. I have my blazer in the car. I'm thinking I'm good, and I'm talking to Owen about the meeting tonight. And all of a sudden, my daughter's saying, hey, I'm good. All of a sudden she goes, oh, I've got to go in at 2 a.m. And then all of a sudden it's 9 p.m. And it was the afternoon, and all of a sudden I get the call at like 2:35 or something. You got to come get him now. And then it's like, my wife is calling while I'm on the phone with her. I had to come back here, get my wife, go to Yale New Haven Hospital, change car seats with my son-in-law, and then then I'm sitting in traffic, if you know New Haven, and I get back up here, drop my wife, my grandson off, race over here, of course, grab my blazer, leave the tie, the heck with it. I come running in here. I think I ran right by the window, but I was too intent. I was here 7 years doing this exact same thing, and I thought it was way upstairs. So I'm going upstairs. I don't see. And then I come downstairs, and I find you guys, and I was sweating. I don't know if you noticed and everything. But my wife and I kept on saying as we were driving, and we were like excited and nervous and everything, and I thought of John Lennon's line, his lyric in this song Beautiful Boy, that says life is what happens when you're making other plans or busy making other plans. And I thought that couldn't be a better theme for what I have to talk to you about today, and that's advanced directives. And I got great news, too. I'm not going to talk about your dying like Chuck had to talk about, or Anya had to talk about your incapacity when you're whistling Dixie and you don't know your own name, or you can't even handle your own affairs. I'm going to talk about things while you're alive, while you've got capacity, and the foresight to know, hey, if I take these steps now, I don't have to worry about those things, because I say that what I'm here to talk to you about are advanced directives. And quite simply, those are documents you sign while you're alive and while you have capacity that help in the event that rainy day comes and you need those. You need that help, because we don't have crystal balls. We don't know if something's going to happen like today that happened to me, but far more catastrophic. And these things will help you plan for those. And I say they're like having an umbrella. If you have them, then you probably won't need them. But if you don't have them, at one point, you or your family are going to be wishing, I wish, after that seminar, that I went out and did these things. So as Judge Egan said, I've known Owen since high school, so, it's been a progression. I'm going to talk about advanced directives. I'm really going to concentrate on powers of attorney, but I'm going to quickly review the other ones. And the first one that is probably and perhaps the most simple advanced directive, it's called a living will. And a living will is perhaps the most simple law the legislature ever passed. It's just a couple of paragraphs. And it's triggered by your incapacity or your inability to communicate your wishes regarding your health care to your physician. or your healthcare providers. And the reason it's in writing is because it's only going to be used when you can't express for yourself or give informed consent to your healthcare providers. So it's in writing for a purpose, because it's used when you can't speak for yourself. It takes its place. And it goes on to say that it's designed to be triggered by your incapacity. It's directed to your healthcare professionals. And it goes on to say that if your condition is ever deemed terminal, where it's short term, okay, we're all terminal, but this has to be more short term and something that's foreseeable and that your doctor says it's coming. You're not going to duck this one. It's irreversible, it's incurable, and it's short term. Or if you're in a persistent vegetative state or a permanent coma. Okay, those also have to be certified as something that's irreversible or incurable. So that triggers your living will. And what do you say? You have options as to what do you say or don't want to say, but for the most part it says, if that point ever comes, and it's not a question of if, it's a question of when, you say no heroics. I don't want CPR. I don't want tubes tied hooked up to me, artificial means of providing hydration, nutrition. Comfort measures are always provided, or CPR, or artificial respiration. So those are the elements, and you can elect to have some of those provided or not. But the living will basically says no heroics. And it's important to know that have it in writing, and I tell my clients who sign them, the next time you go to your doctor, take one with you. Have them scan it into their records and then leave with it. So then it's part of your official record. So that's quickly living wills. Like you can't opt out of certain ones. I once had a doctor actually write into the living will that his condition is to remain unchanged for 30 days. I didn't think it was such a enlightening thing to say about his own profession, that maybe these doctors could make mistakes. But the fact of the matter is I got it. He was worried about the fact that he could come back. So that's a living will. Living will, while you're alive, you're saying in advance, I don't want these things if these conditions are present. The second document I'm going to talk about is, and I'm going to spend the most time on it, power of attorney, because there are such things called healthcare proxies. But I actually think they're like a sub-form of a power of attorney. So it's the power of attorney I want to spend a lot of time on. If I was to sit up here or sit through all of Judge Egan's presentations, and you were asked to have one document, I would pick a power of attorney. Wills are great, but they're things you can do that can designate beneficiaries or payable upon death clauses, or you can deal directly with financial institutions. You can have joint ownership of assets and set that up in advance so that your assets pass without needing a will. But a power of attorney really helps you, in my opinion, probably far more in a lot of different areas about death planning, incapacity planning, health care, everything. It's called a general power of attorney, and Connecticut has a statutory form. Now, as I was running out of my office, I also ran away from the handouts I was going to have for you. But they would have been confusing anyway, and I almost looked at them and said, they're so confusing that maybe it's not, maybe I shouldn't even pass them out. Well, you're not getting them anyway. I also had the Connecticut general statutes that govern power of attorneys, because our short-term power of attorney in Connecticut actually incorporates by reference about 24 pages of single-spaced statutes and pages. And then what it does is it breaks down into subcategories in one line, different powers that are usually represented by at least one page. So it's really broad and encompassing. It's a very powerful document. And it's an agency agreement between the principal, who's the person signing it, and their agent, the one they're appointing to act on their behalf. And it is an agency agreement. And a power of attorney can be a durable power of attorney or non-durable power of attorney. I won't even talk about non-durable, because non-durable may be when you're leaving town and have to sell a piece of property or something. You temporarily appoint somebody, and you don't expect that power of attorney to really be around for a long time. It's temporary in nature. But a durable power of attorney is designed to survive your incapacity or your incompetence, and that's really what you want it for, because while you're able to handle your own affairs, you don't need it. And what it really does is allow for the orderly and immediate transfer and transition of handling or managing your affairs. Now, Anya spoke about conservatorships and all the precautions and the protections and what you have to go through. Those do take time. And in some instances, you don't have a lot of time because power of attorneys can have medical decisions. They can address medical decision making. It could be financial decision making. And there could be vital or time-sensitive decisions that need to be made during that time. And the last thing you want is to go through the process, which Judge Egan takes about, what, 40, 45 days perhaps on a conservatorship? If you're, yeah, roughly that amount. So a power of attorney, you sign it, and it's designed to take effect in advance. So you'll always want a durable power of attorney. I always recommend the statutory short form, which is, I have it on a front page and on the back side. So it's one sheet of paper. It encompasses a lot of powers. And it really incorporates about 22 pages in just 2. They're very, very powerful documents. Now, I talked about financial matters. I talked about health care. Just about anything you can imagine are in there. And in fact, in 2018, there was a really a nice substantive change to the powers of attorney statutes that started bringing in a lot more powers and brought in more up-to-date regulations or provisions that you might need. For example, electronic transactions. How many things are done online now? Our old ones didn't say anything about that. It also talks about enforcing or making sure that you can bring lawsuits to enforce or force people to recognize those, because you'd go to some of these banks and walk in and they'd call up their lawyer up in Boston. The lawyer said, oh, it's more than a year old. It's no good. And I'd say, oh, really? What law are they looking at? Because I've been practicing law in Connecticut a long time, and I don't see anything that would do that. So there are a lot of more powers that were brought in 2018 that make it a more comprehensive document. Okay, how long is a power of attorney good for? It's really good until you either pass away, because you can't have an agency agreement if you've passed away. And it's an agreement. It's a relationship between the agent and principal. So it ends when the fiduciary picks up, as Chuck might have talked about, an executor of an estate that has a will or administrator of an estate that doesn't have a will. So they take over where the power of attorney ends. It's a handoff. How do you revoke them if you want to revoke them? Well, you can do acts that are inconsistent with wanting that person that you've appointed. You can say it out loud. You can do it in writing, which I'd recommend, and do a revocation in writing. And there's a lot of things. I hardly have seen revocations over the years. Do you know why? The thing I stress the most is whoever you're going to appoint, make sure you pick somebody that is trustworthy, you don't have to worry about. Because if you're ever worried about them mishandling it or misusing it, you're picking the wrong person. You're not thinking about the right person. So it should be somebody there are just no questions about. Somebody who's an ally that you know is there and has the ability to handle these matters. The other thing that I want to talk about is the 2 types of power of attorneys that talk about it's either springing power of attorney or an immediate power of attorney. A springing power of attorney is one that says, hey, if I am ever incapacitated or I'm incapable, then I'm appointing this person as my agent. And I don't do those. I don't like them because how do you know when you're relying upon a third person who's going to make that decision? Well, I don't believe that person's incapacitated, or give me proof. There's more delays to that. And if you really, like I said, are going to appoint somebody that you have full faith in, that you know is going to be there, and you don't have to worry about, you shouldn't worry about them abusing it before your incapacity. You just tell them, hey, listen, it's in my desk drawer, it's in a strong box, you tell them where to find it, or you give them the copies of the power of attorney in advance. And they're fully customizable. You can reduce the powers. You can take powers out, you can add powers in. It's a personal document. It's not just a piece of paper that somebody rips off a Cleveland legal blank. I know, I'm sure Anya and Chuck and Judge Egan all work on these power of attorneys. I know I have over years. I see some of my provisions in other law firms' powers of attorney when I review them sometimes. So, and I'm not offended. I think it's great because these are all designed to make things better or more comprehensive. And it's a lot better than just peeling them off a pad or taking them out of a book that you could find or finding one online. How long did I have?
You're almost done.
Oh, almost done. Okay.
You got 1 minute.
I got 1 minute. All right. The last I'm going to talk about is this. I used to just be happy with the fact that healthcare provisions in a power of attorney are there, and I never did the healthcare power of attorney or healthcare proxy as a separate document. I'd say it's in there, it's comprehensive. Why have an extra one? Well, I changed my mind on that years ago because doctors are busy people, and the last thing they want to do is plod through my comprehensive power of attorney to get to the few sentences that they're really looking for. So I started to do one on its own so that you could take it in with that living will to your doctor that just talks about healthcare provisions. So in effect, it's a healthcare power of attorney, but I really think it's an offshoot of the general power of attorney by giving those powers to a third party and allowing them to make healthcare decisions on your behalf. I actually think they complement both the healthcare power of attorney and the living will complement each other very well. Because where the healthcare power of attorney can drop off, the living will are your wishes, and you're telling the doctor. You're not letting some third party that you put these decisions on their shoulders. When it comes to removing life support, it's a really tough decision to put on somebody's plate. And that's why the living will together with the healthcare power of attorney, I think, complement each other very well. And I think that's about it. Well, thank you very much.
Thank you, Drew. That was wonderful. A couple of things that I just wanted to emphasize that Drew talked about. With regard to the power of attorney, the power of attorney needs to be in your possession in order to use it. So if Drew's clients or Chuck's clients or Anya's clients or my clients have given a power of attorney to someone, it doesn't mean anything until that person physically has that piece of paper in their hand. Without that piece of paper in their hand, they can't do anything. If they go to a bank and they try and withdraw funds, they have to show the original power of attorney. And as Drew said, don't give them the power of attorney, let them see it, and then they can take a copy of it and say, I certify that I've seen the original, because you'd need 50 copies, 50 originals, if people were taking your original copy of the power of attorney. Now, Attorney Shimkus is going to tell me sometimes the original has to go to a town clerk's office or to some people, so you might do a few. So Anya, Attorney Shimkus, Attorney Kearns, and I will do a few powers of attorney, and we'll have people execute maybe 3, so that they have a spare or 2. But it can't be used unless the person has it in their possession. They can't walk in and say, I'm the power of attorney for my mother. I'd like to change the account, or I'd like to withdraw funds. Power of attorney has to be on file with the institution that they're using it with. One of the other questions that I ask, that Drew asks, that Anya asks, that Chuck asks their clients, do you trust the person that you're giving the power of attorney to? I ask that of spouses. Do you trust him? Do you trust her? Do you trust her? Whoever your partner is, do you trust them? And they inevitably say yes, but that's a question I ask because you're giving, as Attorney Kearns said, a lot of power to them. And if they have that document and they know where you keep it, they can grab the document and they can manipulate assets and do things with it. Another point that Attorney Kearns made that I thought was a very good point is leave your living will on file with your medical professional. That's good. Once they have it in those medical records, they don't care about originals. They just look. The doctors look and they see it. They're going to give that. They're going to give that credence. They're going to give that weight. And I think that was it. So now I want to open it up to questions, and I'm going to moderate those, but I'm going to let the experts answer the questions. So, yes, sir, in the back.
I'm just wondering, when do you do a power of attorney? I mean, you do the living will now, but do you do a power of attorney now, and do you do it when you have a spouse, like for each other, or how do you, what's the timing?
I'll let the panelists answer it, but remember the building blocks were the will that Attorney Shimkus talked about, appointment of a conservator that Attorney Goldsby talked about, Goldsby-Wells talked about, and then the power of attorney, which is another building block that Attorney Kearns talked about. The other things that were touched upon were an advance directive, living will, and then the healthcare proxy. So you do those all together now. If you go to any estate planner, they're gonna help you do those now. But Attorney Shimkus, would you like to?
Yeah, I mean, I'll just add to that. That's exactly what we do it as a package. When you come to my office, you're going to end up doing a living will, an appointment of a healthcare agent, power of attorney, and a will. That's what we typically want people to do. Now, not everybody does it. Some people say, I don't want a living will. Okay, but at least we've offered it. I would say 9 chances out of 10, you will find that they will do the entire package when they come in. Because a lot of times people want to do these documents and quite frankly, forget about it. They don't want to keep dealing with this issue. They don't like to talk about these issues. So they want to get it done, they want to have it on file, and they do it all at once. So generally speaking, my experience is we do it all at the same time. I don't know if the other panelists have the same.
Attorney Goldsby-Wells?
Yeah, I would say to do it all at the same time, and you can do it now. One thing to think about when you do execute the documents is to think about who the successor agent or representative will be, just in case the person that you appoint currently. So I usually do it for couples. They typically appoint each other, husband and wife, they appoint each other. But let's say they're all traveling together, something happens, one's incapacitated. Those are things that you want to think about. So if that person can't do it, who do you want the other person to be? So I always recommend making sure you have a successor.
Attorney Kearns?
Yeah, I agree with that. I would execute them all as the same package. But I would also recommend that you, every few years, 5, 6, 7, some people are 10 years, have it looked at. Because I referenced back in 2018 when the state made some really good changes to the power of attorney. And if somebody brought in a package and everything else looked great, my line is, if it's not broken, we're not fixing it. But if somebody came in after 2018 with the old power of attorney, I'd say, hey, listen, you'd benefit by having the updated version. So it doesn't hurt every few years, handful of years. Go have it looked at. I don't even charge to sit down and go through it. If it's not broken, we won't fix it. But if there's something that is meaningful as far as that would make a big change, I recommend it at that point.
I think the attorneys that are there would tell you that if you come in to review your documents, they're not going to charge you to review the documents every 3 years, every 4 years. It would be only if you change the documents, if there was a change. Yeah. That's our policy, I'm guessing.
Yes.
Attorney Shimkus and Attorney Goldsby-Wells, yeah. Attorney Kearns. And then the other thing is, place those documents in a safe place. Everybody used to have safe deposit boxes at banks. They've kind of gone out. I don't think people really do that. So we always say put those documents in a fireproof box and have them in a place where your family or people know where they are if they have to get them. So, any other questions? Yes, ma'am.
My father left a will, was drawn in Germany, but the assets are in New York, Washington, and globally. Could I come to your court to have it handled? And part B, do you do a forgiveness review?
Let me give you the mic. So sure. You said your father had a will.
Yes.
Go ahead.
And it was handwritten in Germany, because in Germany all wills have to be handwritten.
Handwritten in Germany?
No, it was done in Germany, but handwritten.
Written in German?
No, in English.
Okay.
But I'm a U.S. citizen, so he was not. But he left his will in English, but it had to be handwritten. That's their law. You have to do it handwritten. Now, I'm the heir. Can I come to you to handle my estate? But some of the assets are in Washington, some of the assets are in New York, and some of the assets are global. Can I come to you to to handle my estate? And the last part is, do you do a forgiveness refuge?
We're going to let the people come to the podium because I think there is a microphone for the channel.
Judge Egan,
So
there's a
Attorney-
mute button on that. I had muted it.
Yeah, just hit the mute, it should go back on.
Okay,
There you go.
okay, thank you. Attorney Shimkus, why don't you go ahead?
This sounds like a law school question on the bar. Which I did pass already. So, first of all, it's a very complicated situation that you have. I believe, and at the international, I think that will is going to have to be accepted in Germany. There's going to have to be an ancillary estate here in Connecticut, and then ancillary estates in each of the jurisdictions where the property or assets are being held. So you're going to end up opening a bunch of different estates, I believe. Certainly the Connecticut assets, you would have to go ahead and open an estate here in Connecticut to probate the Connecticut assets. But also the other jurisdictions, you're also going to have to open up estates in all those other states that you mentioned, including DC.
Can you handle this?
I can handle it. It'll be cumbersome, but of course, I think any one of the attorneys sitting here can handle it, sure. But it will be cumbersome. It won't be a simple Connecticut estate. It will be lots of moving parts.
Okay. Do you do a forgiveness refuge?
I don't know what you're referring to, a forgiveness.
Do you know the forgiveness recuse?
I'm not sure, forgiveness, what?
Recuse. Forgiveness recuse. It's where you did something wrong in the past. I have to come to a judge and I present what I did, and he forgives me, and he gives me a forgiveness recuse.
We don't forgive anyone here in Connecticut. So my simple answer is I don't think that's going to work here in Connecticut.
I can give you time to research.
Any other questions? Yes, ma'am.
This might be somewhat case dependent, but if your executor is across the country, and does it take a lot of time? Like, because our oldest child, our daughter, lives out in Seattle, and we've made her our executor if we're both gone. Does it require so much time in person that that would be a hardship? Or can things be done with her here a short time and then going back to her family? I'm not sure what is involved.
So you've named your daughter, who's living in Seattle.
As our backup executive.
So you want to know if it will take a lot of time and if it's possible.
Does it have to be someone like nearby?
Good-
Because, yeah.
Good question. Attorney Goldsby Wells, would you like to handle that? Why don't you come up here, please?
Oh, you're gonna make me move. Hello? Oh, it's good. Okay.
Well, the
Got
other
it.
microphone deals with the people that you picking it
Is
up?
good?
Okay.
Okay. Save me the steps, Owen.
All right.
No, so I think that's a great question. I would say it depends. Typically, you want to have someone that's local, but it also really focuses on where the assets are. I've definitely assisted clients that have executors that are outside of the state, but there typically is some sort of travel if they have assets, bank accounts, things of that nature, because they may require the original death certificate. There are things that do need to be handled in person in Connecticut, but it's certainly possible. I think it really just depends. It's a case-by-case basis, depending on where the assets are and then how much time the person has to do essentially that thing. I've seen it where you could probably get it done within a shorter period of time, maybe within a 30-day period. You schedule ahead of time, take a vacation, travel, do what you need to do, go back. It really just depends, but I'll see if other attorneys have other thoughts.
Attorney Kearns?
In this day and age of the emails and the scanning, and now even the attorneys, we file everything electronically with the probate courts now using Turbo Court. It's really made the distance a lot shorter, and it really comes down to the time of the person turning it around and signing it and sending it back. So I would say don't let that be any impediment to you appointing somebody that you believe should be the next one you want to appoint, no matter where they live. Yeah.
Attorney
She's
Shimkus?
quick. I think she'd get it done pretty efficiently. There's a good help.
I do think, though, that Anya makes a good point with respect to what type of assets are in the estate. Because, if you have lots of real estate, maybe a home with lots of belongings in it and so forth, and that executor needs to deal with those issues, it may not be as convenient for someone that's out of state to deal with those issues. But to Drew's point, yeah, in this day and age with the electronic transmission, and we actually DocuSign our documents now with our clients, you can certainly do the paperwork electronically and remotely. It just sometimes does become somewhat difficult if there are assets that need physical presence to handle. And so you really, have to consider that. On the other hand, you're picking someone presumably that wants to do that, wants to have that function for you, wants to fulfill the responsibilities that you're asking them to fulfill. So.
Okay, thank you very much.
Thank you. Yes, sir.
Is there any conflict in the idea that the executor may benefit from this whole process? In other words, benefit materially from the whole process we're talking about? And question two would be, can there be two executors?
Okay. Both good questions. So the first question we'll deal with is there a conflict if the executor is actually also a beneficiary of the estate? I'll start with Attorney Kearns.
I wouldn't call it a conflict because a lot of times you're appointing family members who are also beneficiaries. There are rules against self-dealing where they can't just put themselves at the front of the line. And I'd say that anybody appointed actually has to take extra special care that they don't take the lead themselves as far as making sure they got something ahead of somebody else and that they acted completely fairly. And that's what the courts are there to do too. It's not uncommon for there to be some disagreements here or there. And if it ever rises to the level, then I usually will file a motion for a status conference with the judge and informally sit down, not with the full trappings of a full hearing, and just run it by the judge. But it's always best at that point now, in Connecticut too, if a fiduciary is going to be like buying something or tendering a bill or reimbursement, they have to go ask for permission from the judge too. So there are a lot of safeguards there, and it's hard to prevent that type of what you say is a conflict just because of the family dynamics. That it's usually a family member that is the fiduciary.
Attorney Goldsby-Wells?
Okay. Yeah, so the one thing I think of is I know I had a case recently where there was maybe 8 or 9 siblings. It was a lot of them. 2 of them wanted to be the administrator, or the mother passed without a will, so the administrator of the estate, and I think they also had access to the bank account. So before the will was even, or at least the administration of the will was in probate court, someone took a bunch of assets and gave it to the other siblings, but the other siblings didn't get anything. So we showed up at probate court where half of the siblings are like, I got $7,000, and the other half is like, hey, I didn't get anything. And I'm sure their mother was rolling over in her grave to see all of these things going on. And so that's what the probate court is for, right, to come in and to try to rectify some of those issues. So as Attorney Kern said, I don't know how much you can really say that there's, sort of that there's always going to be family conflict. Typically, you're appointing someone that's a family member, so it's typical that they can be an administrator, an executor, and also a beneficiary. That's very common, but they have, fiduciary duties that they are supposed to follow. So again, make sure you're appointing someone that you believe is going to do it properly, and the court kind of steps in whenever a situation occurs where that's potentially something that did not happen.
Attorney Shimkus.
Yep, so the executor is going to have to file an inventory that lists all the assets that were owned by the decedent at the time of their death. They're also going to have to file a final accounting. They're going to file return of claims of debts that were paid were the final bills. And those are under the watchful eye of the probate court. And believe me, under the watchful eye of the other interested parties in the estate. Lots of family members are watching, okay? And especially if there's multiple beneficiaries, you will find that everybody's looking at everybody else, okay? So, you know, I don't think necessarily it's a conflict that a family member who's also a beneficiary acts as the, you know, executor. And quite frankly, a lot of times they'll do it without charging for it. And so therefore that's a benefit to the estate. To your second question, which is one that I get a lot, which is, you know, is it better to have 2 executors, or is that okay, or is that not good? You know, I don't give advice as to whether it's a good thing or a bad thing. What I do say, though, is that whenever you have to make a decision by committee, it's a hell of a lot harder than making one person be the decision maker. So that's not to discourage people from having, you know, multiple executors, but it can sometimes make it a more difficult process if there are 2 executors or 3 executors. Now, if they're all getting along and that's what mom and dad wanted, fine. But again, you have to think about who you're naming and whether those 2 people or 3 people are going to be able to get along well in administering your estate.
Just to add to that, 2 executors become difficult, but it's something that can be done. Some people say, I can't decide between my 2 children. They get along and they'll work together. We've all dealt with that. It's easier to deal with one person. And I think what each of the attorneys is saying, that the person appointed as executor has a fiduciary duty to the estate. And so each of us will tell that person, I represent you as the executor, you have an obligation to the estate first, and then you're a beneficiary second. So you're going to treat all the beneficiaries, even if I don't like my brother Billy, or you know, my brother Freddie is really giving me a hard time, or Susie. You have an obligation to treat them the way the person who created the will, the decedent created their will, says. You have to treat them the way they wanted them to be treated. So, any other questions? Yes, ma'am.
You mentioned keeping the documents at home in a strong box. Can you keep like your will with your attorney, or is that a bad idea, the original? Well,
I'll let the attorneys talk about that. There's all different philosophies on that. Attorney Shimkus?
Oh, that's a great idea. No, I would say 3/4 of my clients do keep their wills with us in our safe. You know, we obviously have to tell them very carefully that they need to make sure that family members, the executor, successor executor, all know that we're handling the will. We even have a letter where they sign it and they check off the box that we're holding it. Because, you know, if someone passes away, we're not necessarily monitoring every single day, every single client. So we'd want a family member or an executor to contact us to get that original will, which will be needed to go ahead and admit to the court.
Attorney Goldsby Wells?
So I personally don't like to keep the original copies. I think I'm afraid that I will lose it, and I would rather the responsibility to be on the client. But what we do is we provide it in, you know, a nice sort of, you know, binder protected sort of thing. We tell them to put it in a safe if they have it, keep it in a dry place. But what we will do is at least scan it so that I have a copy of the digital files of everything that we've signed. That way, just in case something happens, I have a copy. It's also for my record, so I know who I dealt with, but I give the originals to the client.
Attorney Kearns?
When I was a young guy, I would take the wills and store them. And the older I got, the more I started thinking, I don't think I'm outliving a lot of these documents. Why would I encourage them for me to hold them for them? So I actually recommend, you know, at those times that they get a strong box. They have it accessible. Don't use safe deposit boxes because they're tough unless the person who's your fiduciary is co-signer on it or has access. So I will if somebody wants me. We've got the, you know, the thick vault that's a file cabinet, but it's been quite a change over the last few decades. So
I had a client that used to store his will in his freezer because he said to me, that's the last thing to burn in the house if it burns down. And I thought, okay, but if I'm going to get a dish of ice cream at your house, I might be checking out your will. But anyway, those are great answers. Any other questions? Yes, ma'am.
You mentioned that an individual should have a will if they own things on their own. what about like myself and my husband, everything is in our name? Or what about POD, everything's joint, house, property?
So,
How
We have
is
some
that?
investments that are POD and TOD.
so
Individual need a will for that?
the question is, and let me just repeat it for everyone. The question is, there's a husband and wife, and they have named each other the beneficiary of all the accounts, or they hold things jointly, which means if one passes, the survivor receives those assets. They're saying, do I need a will in that case when everything is held jointly? Attorney Shimkus.
Well, on the first level, you probably don't, right? Because everything is going to your surviving spouse. However, what happens when the second is to die? Now you no longer have a surviving spouse. How are those assets going to be directed? If you don't have a will, those assets are going to go by intestate succession. And we've already talked about, you know, the pitfalls of having it go by intestate succession through the statute as opposed to your will. So I'm an advocate for having a will. They're not expensive, especially simple wills to draft up and to execute. And again, in your scenario, the first to die, probably not an issue. It'll be a tax purposes only estate. But when the second is to die, there's no beneficiary unless you take the steps to name beneficiaries, PODs, TODs, and designated beneficiaries for every single asset. And then again, what happens if you acquire an asset and you forget to do that, or you don't do that, and you don't have a will? Again, you go back to intestate succession, more cumbersome process.
Attorney Goldsby Wells.
The only thing I will add is make sure too that there's one thing that has come up a lot with the documents that name each other as a spouse. Make sure it's designated who the spouse is. Because let's say it's a situation where someone gets remarried.
Oh.
You don't want your assets to go to somebody else's new spouse. So that's all I would add there.
Attorney Kearns.
I call what Chuck was talking about the race to the grave. And it's true, but I'm going to talk about another example, and that is, I could use an example that's draconian, like you get hit by a bus and all of a sudden you have a personal injury or wrongful death lawsuit. But I like to use the example, the reason you died is you hit Powerball. Now you have an asset, and a really big one, that needs to be probated. And if you don't have a will, then you're going through an estate without one. So it's always best to have one, because you can't always guarantee that you're going to have that all your assets will have beneficiaries on them.
And I think Attorney Shimkus talked about the wills. It's a basic building block. It's very good to have a will. And there may be a stray asset that you haven't captured. You may have your contents of your home. You may have a gold pocket watch that has been in the family for 100 years that you want to go somewhere. Those things have to be considered. It's not hard to do a will. You just name each other the beneficiary of the will, if that's the right advice. So it's important to have a will. You don't want the state of Connecticut dictating to you where your assets are going to go. I think we have time for one more question. Ma'am.
My simple question is, does the probate court require visibility of all assets? Or could you strategically tie certain assets through a joint partner or a joint cosign or like a beneficiary, and then sort of carve those assets out? So really, does the probate court process require full visibility of all assets?
So I think that's a good question. So you're talking, the question is, does the probate court require visibility of all assets, disclosure of all assets? Is that proper? All right, I'm going to let Attorney Shimkus, and Attorney Goldsby Wells, and Attorney Kearns go. Attorney Shimkus.
Yeah, I think I understand the question. I mean, basically you're asking if all assets have, some beneficiary, can it basically fly under the radar? And I would argue that no, it cannot, because you still have an obligation to file a tax purposes only estate and name all these assets that have joint names or payable on death or transfer on death on what's called a CT 706, and if it's under 13.9 million, a CT 706 NT, which says that there's no tax, but you still have to report them. And frankly, you want to report them for a variety of reasons. Number one, you'll pay a probate court fee, but the flip side to that is you'll also typically get a stepped up basis on the assets if they're on the CT 706 NT, which is a dramatic cost savings if you go to liquidate that asset afterwards, a cost savings in capital gains tax. I don't give out tax advice, but The bottom line is all assets, regardless of whether they're in your name only or they're jointly held or payable on death, should be disclosed to the probate court and a CT 706, NT or 706 without an NT.
Attorney Goldsby Wells.
What he said.
Attorney Kearns.
Oh, great point on capital gains. Anything that passes through the estate gets a step up in basis. However, just a reminder, the tax return with listing the accounts that passed under a beneficiary, that return is confidential. So it's not like anybody can come in and take a look at it unless the probate court authorizes them to see it. So there is, you talked about visibility, there is confidentiality with that. It doesn't become visible unless the probate court allows somebody to see it.
So before we finish, by law, you would have to disclose them on the tax return that Attorney Schimpf just talked about. As the probate judge, we do not disclose that to anybody unless there's some sort of litigation and someone asks for a discovery. Very begrudgingly is that ever disclosed, so it's generally not disclosed. However, anything that's not held jointly, that doesn't transfer outside of the estate process, would have to be listed on the inventory as was discussed earlier. So with that, I just want to say none of this is legal advice. This is informational only. I have to do a disclaimer so you have that. You're welcome to call any of these very good distinguished attorneys if you have any further questions. Our next segment is estate taxation and the use of trusts. It will be on Tuesday, November 4th, from 6 to 7:30 p.m. So we look forward to seeing you there as well. So thank you all very much.